Again, and again, and again, and again, Mr. Woods. 8/14/23, assault of a family member. 6/9/24, violation of protective order, assault bodily injury. Another assault bodily injury. February of 24, assault of a pregnant person, for which you're on deferred now, and now you've picked up another case. You now stand charged with criminal mischief.
Pause right here. Did you catch that? 6 separate cases in just a few months. Judges don't look at charges in isolation. They look at patterns. And when a judge starts counting cases out loud like this, that's a warning siren. At this point, the courtroom tone has already shifted from what happened to why does this keep happening?
You are facing up to 6 months in jail and or a $2,000 fine. So 1, 2, 3, 4, 5, 6 cases, all in a matter of months. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Mr. Woods.
Yes, Judge. The defendant was traveling with the complainant to go see the defendant's child with his child's mother. The defendant continued attempting to be sexual with his child's mother, and the complainant engaged in a verbal altercation with the defendant. Upon arriving home, the defendant exited the vehicle and the complainant drove to a store close to her home.
This part matters a lot. Jumping on the hood of a moving car and smashing a window isn't just drama, it's evidence of escalation. And even though the damage is only $300, the behavior itself tells the court this situation is dangerous. Question for you, should dollar value matter less when someone's safety is clearly at risk?
The defendant took the complainant's iPad and walked and followed the complainant to the Kroger. The defendant then jumped on the complainant's hood as she was driving and struck her window multiple times with a rock, causing damage to her vehicle. Estimated damage was $300.
Who is the complaining witness in this case?
The complaining witness in this case is a Jacqueline Perry, who is the same complainant in the assault of a pregnant person.
Tell me he's not supposed to have contact with this complaining witness?
Here's the legal landmine. He's already on deferred adjudication for assault of a pregnant person. That means he was given a chance, a big one. Any contact with the same complainant can instantly flip the judge from lenient to lockdown mode. Deferred isn't freedom, it's a test. And right now, he's failing it.
Guys,
Morgan.
Mr. Woods is on deferred for assault of a pregnant person.
Yes, Judge, I'm emailing the felony prosecutor right now.
Was he, as a condition of that, not to?
No threatening, harassing, or abusive contact with the complainant in that case.
Mr. Woods, I'm going to find that there's probable cause to go forward with your case. I'm now sending you for a drug test. I want to know what, if anything, is in your system. If you fail to go take the test, if you fail to come back, I'm going to revoke your bond, and I'm going to make it so high.
Ankle monitor, GPS tracking, drug testing. 1,000-foot radius. This is the court saying, we don't trust you anymore. Judges escalate controls when words stop working. Be honest. Do you think monitoring actually changes behavior, or does it just delay the inevitable?
On one ankle, I'm going to put a GPS monitor because I'm ordering you not to have contact with this person, and you've shown repeatedly that you're incapable of following bond conditions. And I'm going to put a 1,000-foot radius that you're not to have any contact with this person. You're not to have any weapons. You're not to consume alcohol or illegal drugs. And I'm going to test you repeatedly so I know that you're not using, but I'm sending you now for a drug test. Like I said, you failed the test, and if you fail to come back, things will not go well. Do you understand, Mr. Woods? Yes or no?
Yes, sir.
Take a seat for me. Mr. Burrows, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. You guys have worked out an agreement where they're offering you 180 days in jail. It is probated for 12 months. As part of the probation, you will do a DWI education class, 2 victim impact panels. You must do a TRAS, which is an evaluation to see what other conditions you may need. If they assess other conditions, you must fulfill those conditions. No breath test refusal, meaning if you were pulled over in a car and an officer asks you to submit a breath test, you must submit. If you don't, you're in violation of this probation. Guardian interlock, 30 hours of community service, a $100 donation, one time to Mothers Against Drunk Driving, no drugs, no alcohol. Random analysis. Is this how you understand the plea bargain agreement?
Yes, sir.
Does he have any prior DWIs?
He had one that was dismissed a long time ago, and it was no probable cause based on no alcohol consumption out of Galveston. So
Yes,
we tried to get a pizza at the Courtroom, but it's just because of that. He had a theft when he was a kid, like 17 years old, but it was
Just one.
yeah. But he was he was 17 and he had an employee theft, and then he picked up another theft, but they didn't revoke his probation. It was like $100 from a cash register, but that was a long time ago. He's a volleyball coach. He's a good citizen. He's a good guy. He's turned his life around. His parents are here to support him. He made a mistake this night drinking. He understands that. He's taking responsibility for that. He's doing whatever he can to move forward. And he's in a financial hardship now. That's why we're asking for a reduction in the DPS fine. I've worked with him on payment plans and stuff. I'm going to waive all my fees so he can succeed. So.
The question is, at what point do you get it, Mr. Burrows?
This moment is heavy. The judge isn't just talking about court. He's talking about real-world consequences. Criminal records don't exist in a vacuum. They follow you into job interviews, traffic stops, everyday life. Whether you agree with his delivery or not, the message is clear. The system remembers everything.
You've already had one DWI dismissed. You now have another one. While you're on bond, you have bond violations. So for you to come here and tell me that you've changed and that you're a different person and this and that goes in one ear, goes out the other. I don't believe it. Actions speak louder than words. And you can lie to me, but you can't lie to yourself, and your record. Life is hard enough being a young black man in America today, right? And the more convictions you get, all you're doing is you're making life more difficult. With these theft cases that you get, with these DWI, it's one of the worst cases that you can possibly pick up, because these theft cases brands you as a thief, and people are scared to hire potential thieves, because I'm always going to be thinking, well, if I hire him to work for me, I know that he's got not only one prior theft, but 2 prior thefts. Is he going to steal from me? Same thing now happens with the DWI. You've had one dismissed, now you have another one. What's it going to take for you to get that we mean business, that public safety is a primary concern? And when you don't get it, and when you continue to pick up criminal cases, there are really grave consequences. You need to understand that from now on, after today, you're looking at a minimum of 30 days in jail. No, hold on a second. $90 days in jail at a minimum for any new cases you pick up here in county court. Don't matter how small it is, from now on, you are looking at a minimum of 90 days in jail. Not only that, you pick up another theft, you could be potentially charged with a felony, because they use those as a stepladder to enhance punishment. And when you don't get it, they combine all those to get up to felony court. You could be potentially facing that. You pick up another theft case as well. At some point, you got to get it. And I hope that this is it. And usually, in my experience, being here, at times when we go too easy on people, they still don't get it. You're skirting out of here today. You're getting probation. You're getting no jail time. You're not getting your license suspended. Now they want me to waive. Michael wants me to waive the fines and fees. I mean,
I think he has his family.
Why would we reward,
I want him to succeed, and that's what I think the problem is, that if he doesn't have the money to succeed, it's going to be very hard. He's going to try everything in his power to succeed financially. I just think that's going to be a burden on him. I took it upon myself to forego my fees, and I'm doing whatever I can to help him.
And that's great.
Yeah, I understand
Michael,
that. I just don't think he can't afford it. He physically can't afford it. We're putting the burden on his parents who are here to support him. They're in the back. They're here. He's going to be staying with them to produce whatever fees he has to try to, get back on his feet. But he's trying, Judge. He is. He's been in constant contact with me. We talk every other day. He's literally trying. He really is. And I think if you give him a shot here, he's going to do whatever he can to, prove you wrong.
I don't have to accept this agreement. I could say, no, I don't want this. Well, jail time. I will accept your agreement, Mr. Burrows, but I want you to understand that if you come back here and try to tell me
This is the final line in the sand. Rehab isn't a suggestion here, it's a consequence. The judge is essentially saying, if you test positive again, I'm taking control of your life for nearly a year. So here's the real question. Is this accountability, or is it the system stepping in because self-control failed?